Good afternoon, everyone. Welcome to the latest Fox Williams travel webinar, UK package travel reform. Farina, a partner in our travel team, is going to talk about that. I'm then going to look and do a bit of a deep dive into CMA fines under the new enforcement powers that they've got that we've spoken about on these webinars in the past. We've now got our first case where the CMA has actually imposed one of these fines. So we're just going to do a deep dive and look at how they determine fines and some of the factors that they take into account, some of which are particularly relevant to the travel industry. And after my session, we'll then hand over to Daisy, a partner in our employment team, who will take you through what's happening in the employment rights at the moment and things which are coming down the pipeline there. So I'll now hand over to Farina to talk about PTR reforms.
Thanks, Reese. Yes, so hello everyone. I have 15 minutes to speak to you about the reform of the UK package travel regulations. So the wording for the amended regulations was published at the end of April of this year. It takes effect from the 6th of April 2027, so less than a year basically in which to sort of prepare and ready yourselves for these changes. The PTRs haven't had the breadth of changes that the PTD will have. So on our last webinar, we did spend some time going through the changes to the PTD as well, and you'll see that actually the changes to the PTRs are much more limited. But what I will say is that the changes that we do have are quite significant and they will have quite an impact, especially if you sell linked travel arrangements. There's three sort of key headline changes that I'm going to go through today. So firstly, I'm going to talk about linked travel arrangements and the fact that linked travel arrangements as a sort of regulated product in themselves are being abolished. So having a sort of a separate LTA regime, that's going. Then secondly, we've got an expanded definition of what is a package. So essentially, some of what used to be LTAs will now become packages. So I'm going to have a look into that. And then the third point that I'm going to consider a bit further is this new sort of statutory recovery right that package organisers will have against suppliers. So I'll talk a bit more about that as well. One of the sort of headline reforms is the abolition of linked travel arrangements. So I think it was really, really clear from the responses that the government got to its consultation just how unpopular LTAs were. So two main issues that sort of came out of the consultation responses, and that was that number one, consumers most of the time didn't understand the distinction between what was an LTA and what was a package, and they often assumed that they had package level protection when they had booked an LTA, which, as we all know, on this webinar was absolutely not the case. But there was a lot of confusion there. And then the second point was the challenges that businesses faced when they were trying to determine, have I sold a package? Have I sold a linked travel arrangement? Or actually, is it neither? And especially where you were selling sort of single components that might then turn into linked travel arrangements sort of within 24 hours, it was really difficult to have the booking processes and the systems that you needed in place to be able to identify that that has happened. And then this has turned into an LTA and et cetera, et cetera. So it was essentially decided that the LTA regime added a significant amount of complexity without delivering the sort of proportionate benefits to consumers. So on that basis, the LTA regime is sort of being abolished, although in a way, I guess it's not strictly accurate to say it is completely being abolished. LTA type Bs are going. So that is, they will be no more after the 6th of April 2027. So a type B LTA is where you have a trader that facilitates in a targeted manner the booking of a second travel service from another trader. So it's going to be a second trader, and that booking is made within 24 hours of the first booking. So this especially pre the LTA regime, it used to be really popular with airlines. So you would book a flight with an airline, and then on your booking confirmation page, you would get a link to say, do you want to book hotels in, the destination that you've just booked a flight to? If you were to then click on that link and you made your hotel booking with the hotel website, that booking was in within 24 hours of your flight booking, that was an LTA type B. That basically is going to be completely unregulated from the 6th of April 2027. So what generally did happen is a lot of businesses just stopped sending that link within 24 hours. So you would wait 24 hours before sending a link to customers to say, do you want to book any additional travel services? And obviously you would lose bookings in that time period because people would just go off elsewhere and make their own bookings. So what that means is actually if that was sort of something that you did pre-2018, that's something that you could look to do again after next year if you wish to do so. And then we've got the LTA type A, so the other strand to the linked travel arrangement definition, and that is being incorporated into the definition of a package. An LTA type A is where you have a customer and they select, a combination of travel services for the purpose of the same trip on the occasion of a single visit to or contact with a trader's point of sale, and then they make the separate selection and separate payment of each travel service. So that is a linked travel arrangement type A. So that will now be incorporated into the definition of a package. So I think what we currently have is sort of 6 strands of a definition of a package. That's now going to be 7 strands. So there's going to be these sort of multiple different ways that packages can be created, and LTA type A's will now be a package. So what that means is that if you do have any kind of a booking process that allows customers to purchase travel services under separate contracts with a trader, but it's during a single visit to a point of sale or during a single contact with a point of sale, and the traveller separately selects and pays for each travel service, from next year that's going to be a package, whereas previously and currently it would be an LTA type A. So I would say this is the most significant change to the UK PTRs. We've heard a lot about sort of, the LTAs are going, but actually this is the most important thing, because what used to be an LTA type A will now be a package going forward. So that means that those bookings will receive full package rights. One of the things that I do just want to flag, sort of areas that we can sort of see that there's likely to be some issues in interpretation, is what the meaning is of a single visit or single contact to a point of sale. So they're going to be really important points of interpretation, I think, and ultimately will determine whether a booking falls inside or outside of the package regime. And since there's no sort of middle ground, so to speak, for an LTA, that distinction actually becomes even more important. Hopefully we'll get some guidance from the DBT. So that we have our DBT has its guidance on the package travel regulations that it published in 2018 and has sort of updated periodically since then. We will be getting some updated guidance on what this means. We really hope that we will get some interpretation on this. And if we have a chance to have any kind of input in that, we will be asking for some guidance on these points, because we do think that this is going to be an issue that clients are going to be looking for some guidance on. So I'll move on to the next point now, and that is enhanced supplier redress. So this is a new statutory reimbursement right for organisers. So historically, the PTRs placed primary responsibility on organisers to refund or compensate travellers, even where the underlying problem was caused by the supplier, whether that's a hotel or a carrier or a destination management company. And then recovery against that supplier was generally left to the terms of the contract, of the supply contract between the parties. And as we all saw, that caused really significant issues during the pandemic, when organisers found themselves having to refund customers and then really struggling to recover those sums paid to those suppliers. So as a consequence of that, we've got these new changes, and it basically creates a statutory obligation on suppliers to reimburse organisers where the supplier's cancellation or failure to perform results in the organiser having to make payment to the traveller. And that reimbursement must be made within 14 days of the cancellation. The only thing I'll flag is under the PTD reforms, that requirement to reimburse is actually must be made within 7 days, which would then give organisers another 7 days to make the refund to the consumer. Whereas under the PTRC, we've got this 14-day period. So if you got the refund right at the very end of the 14-day period, you might have a period there where you have to actually cover the refund to the customer yourself to avoid you being in breach of your obligations to refund within 14 days. So I would just flag that. So the this right does improve organisers' recovery position, but there are some limitations to it. So a couple of things I just want to flag. So the right to a refund will only apply where the supplier has cancelled or not provided services. So there's got to be a supplier breach of contract here. It's not going to apply in scenarios where you as a package organizer are having to cancel because of sort of, unavoidable extraordinary circumstances somewhere, but the suppliers themselves are actually in destination, are able to provide the services, so they're ready, willing, and able to provide those services. So if you look at sort of the Middle East conflict, for example, where we had sort of package organisers looking to cancel or having to cancel bookings because it transited through the Middle East, but the suppliers in the destination, so say the Far East, for example, they were still able to provide the travel services. So there are some limitations to when this statutory right kicks in. There's also questions around enforcement, jurisdiction, supplier insolvency, overseas, where it's overseas suppliers. So there's all those issues that will still remain. So for that reason, as a travel business, it's really important for you to continue to make sure you have a supplier contract in place and to review those agreements carefully and not just to try and rely on this statutory right on its own. I wouldn't be surprised if we start seeing suppliers trying to exclude this right in their standard contract. So that's something that I would say you should keep an eye out for when you are reviewing your supplier contracts. I'm just going to use these last couple of minutes to just sort of talk through some things. So as I said, we've got less than a year to sort of get your business ready for these particular changes. So there's a few things that you can do to sort of use this lead-in period to sort of help the business manage the transition, manage the changes. So number one priority should be reviewing your booking journeys and identifying any products that the business might sell that previously may have been analysed as an LTA or even falling outside the package regime altogether, and then reassessing those products under the new definition to see whether actually is something that was an LTA before, is it now a package, is something that actually you thought maybe falls out altogether, actually is it now what would be sort of under the new strand of a package definition or not. So that's probably, I would say, the most important thing for you to consider. You also want to look at reviewing your supplier agreements. So obviously the new reimbursement right is welcome, but I have just talked about some of the shortcomings of that. So you still want to make sure that you have really clear contractual protections, especially where you have suppliers based overseas, which for the vast majority of our clients is most of their suppliers. And then lastly, you do want to be looking at sort of your paperwork, your documentation. So things like your terms and conditions, do they need updating? To see what changes need to be made there. With the abolition of LTAs, if you were selling LTAs, sort of, the information schedules have been abolished as well. So there will be sort of certain some significant changes to the customer disclosure requirements for LTAs that you just need to be aware of and you would need to reflect in your paperwork. As I said, although the sort of changes being made are relatively sort of short, the practical impact could be quite significant for your business, especially where you're a business that sells LTAs. So my advice would be prepare as soon as possible, start sort of get going into that transition period now to ready your business so that when the reforms do come into force next April, you're in a really, really good position to be able to deal with that. So that brings me to the end of my session. I will hand over to Reese now to talk about the CMA.
Thanks, Serena. My session, like I said at the beginning, is going to be a deep dive into CMA fines and to look at the process that the CMA will go through to determine what your fine should be if you are found to have breached consumer law. Uh, Now, before I do that, I just want to mention a few things. We've talked a lot about this subject over the last 12 to 24 months. We've been following it really closely, so I'm not going to go over the new consumer enforcement regime again, other than to remind people who may have not been on those earlier webinars that these new powers came into force in April of last year. Before then, the CMA had to go to court to prove to a judge that there had been a breach of consumer law before they could get their remedy, which would be, an order to force the travel company to do something or not to do something. Um, but under that old law, there were no powers to impose fines. And that all changed in April of last year. The CMA can now decide for itself that there's been a breach of consumer law, doesn't have to go to court anymore. And that means that the process is much, much quicker. And the other thing it can do then is to determine what the remedies and what the sanctions should be. So the CMA can order you to stop doing something. It can order you to make good consumers, so refund consumers, and it can also impose fines and very significant fines, as we're going to come and talk about. Um, the other thing I just want to mention by way of background is the CMA had a big flurry of activity in the travel sector in November of last year, sent out a bunch of advisory letters to travel companies as well as to companies in other sectors, but the travel sector was the number one sector in terms of the number of recipients of these letters. So these were advisory letters telling companies that they shouldn't be doing certain things. And then there was a lot of publicity around that. The CMA also published a lot of guidance at the same time um, around things like, headline pricing, drip pricing, these sorts of issues. So all of that happened in November. Um, what has actually happened very, very recently, about a couple of weeks ago, the government has published a new bill, the Civil Aviation Consumer Protection and Regulatory Reform Bill, which is currently working its way through Parliament. And the effect of that bill will be to give the Civil Aviation Authority in the UK the exact same powers as what the CMA has in relation to sales involving flights. So in the travel sector, if you're selling a flight inclusive package, then when these new powers come into force, the CAA will be able to determine for itself whether you've breached consumer law. And it'll also be able to impose remedies, impose penalties, and impose the sorts of fines that we're going to be talking about today. But just one thing to make clear about here, these new rules will apply to things like non-compliance with the package travel regulations, non-compliance with broader consumer law like misleading advertising or unfair contract terms, but it won't apply to at all breaches. So I know the CAA has been asking for these powers in relation to at all as well, but they'll have to wait a bit longer to see whether they get those because those changes aren't being made with this new bill. So just looking in a bit more detail at CMA fines, and I sort of categorize the sorts of fines that they can impose into two different categories. There's fines that they can impose for breaches of consumer law. So you haven't complied with the package travel regulations, they can fine you the higher of £300,000 or 10% of your global turnover. And that's what I'm going to focus on in this talk. But I just want to mention as well that there are other, what I would call administrative fines that they can impose, where you have fail to comply with some sort of demand from the CMA. So that could be that the CMA has ordered you to do something or not to do something, and you then don't do that. Um, they can impose, turnover-based fines as or fixed fee fines, whichever is the higher. For those breaches, it can also actually impose, in addition to or instead of those fines, daily fines as well, which will go on for as long as the breach is carrying on. So there's kind of a double whammy there. They can also fine you if you provide them with false or misleading information, or also if you just fail to respond to an information notice from the CMA. So this is a formal power that they have to require you to provide them with documents and information. If you don't comply with that, you can be fined, substantial fines, which I've got on the slides here. So on the fines for the substantive fines for consumer law breaches, at a general level, the guiding principles for the CMA are to make sure that the fine is big enough to act as a deterrence. What they're obviously trying to achieve here is making the fine so big that the travel company and other travel companies will see that it's not worth breaking the law and they need to be compliant. So that's kind of the first one. The second guiding principle they have is the more serious the conduct is, the bigger the fine will be. So they want the fine to match the gravity of the offence. And so those two things push the fine up. The third thing, which pushes the fine down, is that they um, want to encourage companies to cooperate with the CMA when they're being investigated, particularly if it means that the CMA can just kind of reach a decision and deal with the matter much quicker than if they have to go through a fully contested process. And they'll offer reductions and discounts on fines, which I'll come on and talk about later on. So the starting point when they're determining these fines is to look at the company's turnover. So if you're being investigated by the CMA and you are found to have breached consumer law, then when it comes to determining what your fine should be, if the CMA decides to impose a fine, which I think they probably will, they will start by determining, well, what is the relevant turnover? And I think the main point to make here is that the CMA are going to look at consolidated turnover. So they're going to look not only at the turnover of the company that's being investigated, but also any company that controls that company, so a parent's company, and also any company which that business controls, so any subsidiary. Um, I should say that, in terms of control, um, we're not just talking here about a majority stake, which is one criteria for control, but it can also include any company which, even if you have a minority stake, if you can materially influence the policy of that other company, then you are considered to control it. So the turnover of any companies which are controlled by or control the company under investigation is all taken into account. So we're looking here at consolidated turnover. And I think that's going to be particularly important for large international groups, which may have a UK subsidiary with a relatively smaller turnover compared to the whole group. What this will allow is for the turnover of the whole group to be taken into account in determining what the UK company should be fined if it's the one that's been found to have breached consumer law. Having determined the consolidated turnover of the group under consideration, the CMA will then go through a five-step process, and it's published guidance to say that it will always go through these five steps. And as we will see with its first case, using these new powers, it did in that case also go through these five steps, quite mechanically. So first one is setting the starting point, which I'll explain in a bit more detail. It then, after determining what the starting point of the fine should be, CMA will think, well, should we adjust that to take into account the fact that this fine needs to be really deterrent of that company. Um, it'll then take into account, aggravating and mitigating factors before it then kind of steps back and thinks, well, overall, is that fine proportionate and is it within the statutory cap? That's the 10% turnover cap I mentioned earlier. And then um, is there a settlement discount to be applied on the basis that you have effectively admitted breaching consumer law early, and therefore you are eligible for a discount on the fine? So just in terms of how they determine the starting point, they basically look at two factors. So the first one is what is the level of harm caused to consumers by this sort of offending conduct? And the way they quantify that is that they look at the economic harm to consumers and the non-economic harm. So the economic harm will be something like, well, how much were consumers overcharged? Like what financial loss have consumers in aggregate suffered because of this offending conduct? So um, for something like a booking fee, which is added, on the last booking page, um, it would be easy to quantify what customers have been charged, what the overcharge is. It would be the booking fee multiplied by the number of customers. Or it could be something like, what revenue have you made from this infringing conduct? And I expect that would be something like, looking at, well, what is the kind of increased conversion rate um, by adopting this illegal misleading countdown timer or misleading scarcity claim, and then they will quantify then what the overall economic harm is. Um, they'll also take into account some non-economic harm. So, have you caused consumer distress? Have you wasted time for the consumer because, they had to go through your entire booking journey before finding out that they have to pay this booking fee, which now means you're not the cheapest and they therefore have wasted all of that time. So it's those sorts of factors which are a little bit more nebulous on the non-economic harm side of things. And then having kind of taken all of that into account, the CMA will decide, well, um, is the level of harm major, which would put it in category 1, significant, category 2, moderate, category 3, or minor, category 4. We don't actually have any numbers in terms of like £1 million is 3 or whatever. But what you will see from this case I'll come on to talk about, and as we will see from other cases, we are going to start to get some guidance from those cases as to what level of harm slots into which category. So we'll see that with this case I'll talk about in a moment. Now, the other thing it then takes into account is how culpable are you as a travel company for that harm? And the CMA has three bandings here. High is, the most culpable um, factor. So, somebody who has intentionally adopted, um, a misleading practice or a illegal practice as part of normal day-to-day business operations. So that's the worst kind of thing. And I should say that doesn't necessarily mean knowing that what you're doing is misleading. It's just that you've made a conscious business decision and it's a key part of your business to adopt a practice which is illegal. So that's the highest level of harm. And the one point to flag here is one factor that will put you in that high culpability bracket is if the CMA, CAA, or ASA, the Advertising Standards Authority, if they've previously made it clear that a particular practice is not allowed, and that could be general industry guidance, if you have nevertheless carried on and adopted that practice, then that will slot you in the high culpability bracket. So you've got to pay attention to what these regulators are publishing is the short answer there, because it will put you in this high culpability bracket. Um, I'm not going to dwell on this too much, but just to say medium is how I would describe as being, well, you've just been a little bit negligent in adopting this practice. So you haven't taken legal advice, or maybe you didn't train your staff properly in what the legal position is, and you've ended up adopting this practice, which isn't allowed, and you've just been a bit negligent. That puts you in the medium banding. And then low culpability banding is isolated one-off incidents where it was somebody's honest mistake. You had compliance procedures in place, but they just didn't work on this particular occasion. It then really becomes quite mechanical. So a code is derived from your level of harm assessment and your level of culpability assessment. So if your level of harm is category one and your culpability is high, then you're going to be given an A rating. You can see that there are different ratings for different levels of culpability and harm here. You then take that letter and you look at the box on the right-hand side, and that gives you the starting point for the fine. So if I have a A rating um, for my conduct, then the starting point for the fine, I'll just take the percentages here as opposed to the fixed fees. The starting point would be 22.5 to 30% of UK turnover. And then there are similar ratings for B, C, and D. And just a flag here that we have to date, and most commentators, when they talk about this, they focus on the fines being up to 10% of global turnover. But I think the point to note is that that's a cap, and actually in determining the starting point for a fine, it could be much higher if your business is UK focused, because the starting fine is going to be a percentage of your UK turnover. And we can see that even the most innocent um, breach attracts a starting point of up to 7.5% of your UK turnover, and the worst conduct is 30%. Having determined that starting point, step two, CMA then think, well, is do we need to increase that to take into account the fact that this is a particularly large group? Therefore, the fine needs to be bigger for it to have that deterrent effect. And similarly, if that starting point of a fine means that you have still ended up making more money from the offending conduct than what the fine is, then the fine can also be increased. So that's what the CMA will do with step two. Step three, they then look at, well, are there any aggravating factors? Um, and I think specifically here for travel companies to take note of is if you've previously been warned by the CMA or the CAA, and I'm talking here about like a specifically directed warning to you from these regulators, um, or you have had an adverse ASA ruling on that particular issue that the CMA is now investigating you for, then that's going to be an aggravating factor and it's going to make the fine bigger. Similarly, if you've previously given an undertaking to the CMA or CAA and then you've then broken it, or if you've just got a poor compliance track record, these are all things which are going to push up the fine. On the flip side, mitigating factors. Well, if you followed an approved industry code of practice, and in our sector, that would be something like the ABTA code of conduct. So if you follow that, but you're still fined, then they don't let you off the fine, but they'll give you a discount on your fine. So following the ABTA code of conduct will reduce your fine. And similarly, if you just do a big mea culpa and you decide to compensate customers early, you admit liability early, you cooperate extensively with the CMA throughout, then those are factors which will reduce the fine as well. And then last thing, just to say, final step the CMA takes is proportionality, and at step four, take a step back. Overall, is this proportionate to the size of the group? Is it within the cap? If it's not within the cap, the fine's going to be reduced to be within the cap. And then step 5, what is the settlement discount? If you've admitted liability early on, then you're eligible for a discount of up to 40% of the fine. This is the AA case, and this is the first fine for a substantive breach of consumer law. And in short, what happened is the AA, the driving school section of the AA, were adding on a £3 booking fee on the very final payment page of their customer booking journey. So they weren't disclosing that on the an earlier part of the booking journey. So that is not allowed. I mean, the CMA have been, very clear about that in all of their guidance, and they want the first headline price that the customer sees to be the final price that they paid. So they took enforcement action. They found that this had affected over 90,000 customers, and that the total value of drip fees was about £800,000. And that this conduct had been going on for about 8 months. This is how it determined the fine. It basically took that exact same sequence as I described earlier. Started off by determining the starting point, took the consolidated turnover of the AA group, which was 1.45 billion, determines that the consumer harm was in the moderate category, category 3. I think the reasons for that were that it was a relatively, in the grand scheme of things, modest financial impact in aggregate. It was about £800,000, which is about, on average, was about £9 per customer. So that put it in the moderate category. The culpability was high because the CMA's published guidance notes about drip pricing, how you're not allowed to do it. So the CMA thought that, well, you should have known that this wasn't allowed, so your culpability is high. That then gave a code rating of B, which meant that the starting point of the fine was somewhere between 15 and 22.5% of the turnover. CMA decided, well, we think it should be towards the lower end, 15%. So 15% of 1.45 billion is £217.5 million. Step 2 and 3 decided not to give any increase to achieve an additional deterrent effect. The fine was big enough, but it did give a 5% discount on mitigation because the AA had been very cooperative throughout. And then the last thing it did was steps 4 and 5. Step 4 on proportionality. This is where the big discount came in. It decided that 206 million odd was disproportionate to the gravity of the offence. So it actually discounted the fine by 97%, which brought it down to 7 million. And then because of an early admission of liability by the AA, that's attracted a 40% discount, which brings the fine to 4.2 million. So I'm going to stop there because we are overrunning a little bit, but you can see how the CMA, when they decide what the fine should be, do go through this kind of quite mechanical process, going through these various stages to reach the fine. And in this case, it was a very substantial fine for the AA. So I'm going to pause there and hand over to Daisy now to talk about employment rights.
Thanks ever so much, Reese, and say thanks to all of you for coming along today. I'm going to finish up with a very high-level overview of some of the changes that we've got in the employment legislation arena, because you'll see from this, which is a very high-level overview of the changes that the Employment Rights Act is introducing, there is a lot of change in this arena. Now, I appreciate that this might not be all of your sort of direct responsibilities on this webinar, but I think it's helpful for businesses generally to be aware of the changes, because some of these are quite significant in terms of liability and potential exposure, and will or should at least impact the way in which you manage people risk in your businesses. So the first thing I'm going to touch on is the change to unfair dismissal protection. And this is something that got an awful lot of coverage in the news, so you might be aware of it, at least from press reporting. Just to put everybody on the same page, at the moment in the UK, employees get protection from being unfairly dismissed once they get to 2 years of service. So what that means is that under the current regime, someone that is with your organisation for less than 2 years has quite limited protection if you're thinking about dismissing them. Now, they will still have protection from discrimination, protection from being retaliated against for blowing the whistle. But if you can discount those as risk factors, it's reasonably straightforward and low risk to exit an employee, provided you do so in terms of the contract. Now, that is changing completely from January of next year, because that qualifying period to benefit from this protection is coming right down from 2 years to 6 months. So what that means is that anyone in your business who gets more than 6 months of service will have protection against being unfairly dismissed. And where that takes you is to a place where if you were to terminate someone's employment who has this protection, and you do so without being able to rely on a fair reason, and there are some fair reasons prescribed at law, and without following a fair process, and there again are some kind of fair processes that apply depending on the reason, the employee will be able to bring a claim against you for unfair dismissal. So we've got a tremendous broadening of the net in terms of employees who will have that protection. And the other change that is being introduced as well, also from January of next year, is a change to the way that those claims for unfair dismissal are compensated. So at the moment, compensation that an employee can receive for a successful unfair dismissal claim is based on financial loss, but it's always subject to a cap. And that cap is the lower of 1 year's pay, or a statutory cap that gets revised every year, which sits at the moment at about £120,000. So that means that employers have a fixed financial exposure for dismissing someone and doing so unfairly. Now, that cap is also going to be removed from January of next year. And rather than effectively being subject to a limit on the compensation that the employee can receive, if they're successful in an unfair dismissal claim, so if they're dismissed once they've got 6 months of service, and they're dismissed without the employer having a fair reason to dismiss, and or without having followed a fair process in that dismissal, and they bring their claim for unfair dismissal in the tribunal and they win, a tribunal will look at their actual financial losses in awarding compensation. So that means kind of loss of salary, it means loss of bonus, it might mean loss of incentives or options. And so for high earners, this claim can become really very expensive, because depending on the job market, and obviously we'll all appreciate we're in interesting economic times at the moment, it might be that someone can credibly say it's going to take them 2 years or 3 years to get another job, particularly for senior people. And so you see those claims becoming really very expensive. So that is a significant shift in the risk exposure for businesses on terminating employment. Obviously, there are various things I think you can be sensibly thinking about doing now to mitigate that risk. And they're on the slide, but just to kind of pick out a few things, it's going to become a lot more important that you manage the recruitment and onboarding process properly, because I think a lot of businesses operate on the basis that they've got quite a lot of time to make a decision on someone, but actually, with this change to the regime, really you want to be deciding whether a new hire is right for you by about month 5. So that means careful recruitment, active management during probation, thinking kind of carefully about the rationale for dismissing someone if you're going to be dismissing, and achieving all of that within quite a short time frame, because we really don't, if we can avoid it, want people that are unsuitable moving beyond that 6 months of service, because if you need to exit them after that, it's going to become more complicated and more expensive. And I think you also need to make sure that managers understand that. So there's probably an education piece there to make sure that people dealing with recruitment, dealing with new joiners, understand what they're going to have to grapple with and think about. So the next change I just want to flag is around collective redundancies. And again, just to bring us all onto the same page, at the moment, you're in a collective redundancy situation if at one establishment, which is normally one geographic workplace, you're dismissing as redundant 20 or more people within 90 days. And if you reach that trigger, you have to go through a collective consultation process. Now, one change in this area has already come into force. It came into force in April, and that is to increase the financial exposure for getting the collective consultation process wrong. So historically, if you fail to collectively consult when you should have done, an employee who's affected by that can bring a claim for a protective award, and that is effectively kind of limited to 90 days actual pay. Now, the legislation has doubled that financial exposure. So rather than 90 days, it now sits at 180 days. So the cost of getting it wrong is and has gone up significantly. And then kind of hand in hand with that, the government is also introducing a wider trigger for when collective consultation will be required on redundancy. So we're going to keep the current threshold that we have, but the government is currently proposing to broaden that. Now, we don't quite know the details of the proposal because we've just had a consultation process close on what this might look like. But the idea is to introduce a threshold that applies across a business. So at the moment, a lot of businesses will operate on a kind of an establishment basis, which means we only have to think about numbers maybe at the London office without having to take into account what might be happening in the Manchester office or the Leeds office. The idea behind the new threshold is likely to be that we're going to have to aggregate redundancies across multiple offices so that you might end up triggering collective consultation in circumstances where you wouldn't have done historically. So I think what that means you ought to be doing to prepare is if you're an employer operating in multiple sites, because we might have this kind of multiple site threshold for collective consultation triggers, I think it's worth thinking now about how your different sites or offices talk to each other, because if they're reasonably autonomous and they don't necessarily know what workforce activities, redundancies or exits are happening, you could inadvertently trigger collective consultation. And if you do that and you don't discharge your legal obligations and collectively consult properly, obviously the claims now are potentially very expensive. So think about tracking systems, think about centralized discussion points so that all of your sites know what the other is doing and we don't inadvertently trigger. The next thing I want to just touch on this sort of whistle-stop tour is trade union rights. Now, obviously, in the travel industry, certain parts of you will already have experience of trade unions, but there are an awful lot of private employers who have never had to deal with a union, and you might be thinking this is a kind of funny thing to touch on in a really short highlight section. For those of you who are larger and who don't currently have to deal with a union, I think it's really important that you understand that that might change, because one of the things that the government is keen to do through these legislative changes is increase the rights and prominence of unions. And they're doing that in a number of ways. But for our purposes today, I'm just going to flag a few of them. So the first is that from October of this year, you're going to have to proactively tell employees that they have a right to join a union. So you have to advertise that in a form to them. In a kind of very significant change, trade unions are also going to have access rights to your businesses. So again, from October of this year, they can ask, do you come into your physical office, or perhaps if you're operating kind of on a hybrid or virtual environment, to maybe join a kind of Teams arrangement or a kind of virtual meeting to advertise themselves and to try and get membership. And on top of that, what we also have then is a significant lowering of the threshold for a union to gain recognition. So it used to be quite hard, there are quite a lot of administrative steps and quite high hurdles for a union to get recognised. But from April of this year, that's come down an awful lot. So we have an environment where you're going to have to tell staff about unions. They're going to be able to market themselves directly to your staff, and the way they get recognition is going to become a lot easier. And we've certainly already seen some private employers be approached proactively by unions for membership. So particularly if you're larger, if you might be an attractive prospect to unions, it's something to watch out for. So in terms of what you might do to prepare, think about whether you're vulnerable to unions. Not all of you will be. And if you are, think about what your staff relations are like. Are they likely to want to join a union? And if so, think about how you might avoid that if you want to avoid it. And that might be thinking a bit more meaningfully about staff engagement. So the final thing I just want to touch on, and we're running out of time, so I'll do this very briefly indeed. The duty to prevent sexual harassment continues to be a real focus point in a lot of workplaces. We've had the duty to take reasonable steps to prevent sexual harassment from October of last year. The threshold is increasing to take all reasonable steps from October of this year. Practically, what I think that means is that if you are not robust in the processes that you take and the steps that you have in place to stop sexual harassment in your workplaces, and someone is harassed, the likelihood of you breaching this obligation is going to be significantly increased. So what I think you ought to be thinking about internally is kind of kicking the tires on the policies and practices you have internally already, or you hopefully do have internally already, to stop sexual harassment. So think about your risk assessments, training staff, think about your speak up policies. For those of you who have international workforces, make sure people coming into the UK understand their obligations as well, because this is something where we see more and more claims from employees for various reasons, and they're obviously quite difficult claims to manage. They're reputationally quite impactful, so it's certainly worth spending time taking steps to avoid them, not least because you also have the legal obligation to do so. So that was a real whistle-stop tour on the employment law changes. I'm going to hand back to Reese, who is going to, I think, talk about some questions.
Yes, well, we've actually managed to answer most of the questions on the chat.
I see.
And
okay.
I think that hopefully everyone else can see those answers as well. But there is one open question, and that's for you.
That's for me. That's fine.
So
I can deal with that. So the question is, I think this will be about the union recognition. Does the threshold, the 2% threshold, apply for the numbers of employees in an office or the whole workforce? So when we talk about the recognition threshold, what a union effectively has to do is get up to, well, at the moment it's 10%, but it could become as low as 2% of the bargaining unit that it wants to represent to join them. And so we're not looking at the whole employee workforce. We're looking at the number of employees in the bargaining unit. And that could be all the office if the union thinks it wants to represent the whole office, but it could be a section of that office as well. So they could say, actually, we think our bargaining unit will be maybe the back office staff or IT staff or staff that work in maybe a kind of call center, and it can focus in that way. So it's 2% of the group of people that the union wants to represent. So it doesn't have to necessarily be the whole office or the whole workforce.
Great. Well, I think that's the end of the questions, and we're also pretty much at time. So I'm going to draw a line under it there. And thank everybody for joining. And just as a reminder, we will circulate the slides and the recording after this call. So it'll be at some point during the next week. So thanks very much for joining, and see you at the next travel webinar.